Business is a risky and rewarding endeavor. Oftentimes, it is the challenge of managing those risks that appeals to many business owners. But as the old saying goes, if you fail to plan, you're planning to fail. This is especially true when it comes to identifying risk and preventing legal issues that can tear at the seams of your business and your wallet. For business owners who take a do-it-yourself approach to legal affairs, it is only a matter of time before a costly lawsuit or an ugly complication rears its head. That's why it's never a good idea to cut corners when managing the legal aspects of a business. Let's talk about some of the costliest risks business owners cannot afford to take. The first risk is choosing the wrong business entity upon setup. There are multiple business entities to choose from, all of which have their own advantages, disadvantages, and tax effects. Choosing the wrong business entity can unnecessarily expose business owners to personal liability for the actions of the business and may result in negative tax consequences. For example, many people believe LLCs are the best entity for a small business. However, for certain types of small businesses, an S corporation actually provides better tax savings without sacrificing the liability protections. Working with an experienced business attorney to determine which entity is right for you and your business, and to make sure it is set up correctly from the start, can save you money in the long run. Second is doing business with undocumented or unclear agreements. The days of solidifying business agreements verbally with a handshake and a solemn promise are long gone. In today's litigious society, clearly written and legally sound agreements and contracts are critically important for several reasons. First, it helps ensure all parties understand their rights and responsibilities, as well as the terms and conditions of the agreement they are entering. Second, well-documented agreements often serve as a business owner's best weapon or shield when disputes arise. Without hard evidence that a contractual agreement has been executed, there is little basis for legal recourse, as it is difficult to prove a he said, she said situation. The third costly risk business owners often take is drafting and reviewing their own legal contracts and transaction documents. Business owners are often unaware of the slew of legal consequences and pitfalls that can exist within the contents of a business contract or agreement. While a buyer could be very clear in his negotiations with the seller, the buyer could unknowingly take on costly liabilities tied to the business when signing a purchase contract. The same is true for a seller who is looking to maximize the value of the business and close the sale transaction. An employer can also incur large tax and other liabilities if she does not have the proper contractual guardrails in place with her employees. Not only could employees leak vital business information to competitors, but labor laws can be violated, resulting in excise taxes and/or penalties. Because labor laws differ among federal, state, and local authorities, it is more complicated to ensure a business is compliant. Our attorneys are adept at spotting contractual gaps, undesirable terms, and adverse consequences. We surgically remove creditors' debts and liabilities from business deals and amend agreements to protect the interests of our clients. The fourth risk is neglecting business transition planning. Most business owners are too busy managing daily operations to think about a day when they may no longer be at the controls. But what happens to the business when the owner unexpectedly dies or becomes disabled? far too many times, I have encountered situations like this one. A business owner in his 60s dies unexpectedly, leaving a surviving spouse, children, and key employees to fight over who should run the business. These fights can be very painful and also very expensive. Many times they lead to the termination of the business. In one case, I was brought in after the business owner died. The surviving spouse and the adult children spent millions of dollars litigating over the control of the business. This went on for years. The litigation only ended because both sides ran out of money. In the end, the business was auctioned off. The surviving spouse and child became estranged. Numerous employees lost their jobs, and many customers were disappointed. When there are multiple business owners, a buy-sell agreement is in order. This agreement can be very detailed, but should at least address these topics: financial and service contributions to the business, division of income and tax liabilities, buying out a deceased or disabled partner, and selling the business to an outsider. Many business owners may not know that service contributions to the business, also called sweat equity, can have negative tax consequences. Sometimes sweat equity is necessary because one or more business owners do not have the financial resources to contribute to the business. If sweat equity is all that one or more partners can contribute, then proper planning is needed to allow those business owners and the business the time needed to pay those taxes timely. Business succession planning can ensure that someone you trust will take over the business without the involvement from the court, that your customers will have continuity of service, and that your family will continue to receive financial support from ongoing business operations. Proper succession planning takes into account organizational structure of the business, key management and staff, compensation and incentive structures, and company finances. Fifth is putting off estate planning. I can't tell you how many business owners have done this only to regret it when hit with a lawsuit or dealing with unexpected disability. When there is no written estate plan, a business is divided up according to the laws of the state of operation. Putting a will, trust, and related documents in place puts the business in the hands of those you choose to manage transactions on your behalf if you become disabled or pass away. When family business assets are in play, careful estate planning can determine a fair asset distribution plan among surviving children that avoids family infighting and in-law joint ownership that could put the future of your business and family at risk. Tax planning is a big part of estate planning as well. There are many strategies a knowledgeable estate planning attorney can implement for business owners to save income and inheritance taxes. Family LLCs, employee stock ownership plans, and dynasty trust are just a few. Just as it is important to put an estate plan in place, it is also important to update it on a regular basis to make sure it meets changing laws and your current desires. The sixth costly risk business owners often take is operating without a professional advisory team. There's a lot to learn and manage when running a business, including documenting agreements correctly, keeping track of your books, and understanding which tax and labor rules you must adhere to. Unless you have time to learn everything yourself, which most business owners don't, you would be best served to team up with an attorney who can help you sidestep a broad range of risk to you and your business, and implement smart tax saving strategies. Every successful business needs an attorney, an accountant, a financial advisor, and a trusted bank or lender as part of their team. The value these professionals provide in terms of protecting you and your business far outweigh their cost. Now you know about some of the costly business risks that can easily be avoided with the help of an attorney. The good news is you can take action now to address any gaps or issues you may have before they become major problems. If you don't have a knowledgeable business attorney on your advisory team, I urge you to seek one. If it's been a few years since you've reviewed your business documents with an experienced attorney, it's time to schedule a consultation. No matter what stage a business is in, no matter how long it's been in operation, it is always a good idea to have an attorney review your corporate agreements, your employee handbooks, contracts, and succession plan every 3 to 5 years to ensure it meets your needs and complies with changing tax and business laws. My colleagues and I are here to assist you when you are ready.